Good evening, warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today a young and zestful advocate, Mr. Mahesh Chowdhary. We are very happy to have you with us, Mr. Mahesh. Welcome to the webinar.
Thank you.
It's time for me to introduce our speaker. Mr. Mahesh Chowdhary is an alumni of University Law College, Bangalore, from where he completed his LLB. He has obtained his master's in business law from National Law School of India University. He's also obtained his LLM from Queen Mary University of London. As a student, Mr. Mahesh served as a secretary for All India Moot Court Association. He also won Viz Moot at Hong Kong in 2012. He represented University of London as a speaker in Oxford University in the year 2014. As an advocate, Mr. Mahesh is predominantly practicing on real estate law and constitutional law. He has a number of reported judgments to his credit and has published several articles. Once again, Mr. Mahesh, on behalf of Advocates Association Bengaluru, I welcome you to this webinar. Over to you.
Thank you. Thank you, Trivikram sir, for such a short and brief introduction about me. Good to hear about sometimes about what you've done before. So, so with regard to the topic, what we are going to, which has been assigned or which have been decided to take, is the issues with regard to the Real Estate Regulation and Development Act 2016 and a perspective and advantages which is conferred upon the home buyers. So essentially, before I get into the entire dynamics as to why this act and how is the home buyers at a beneficial position, and what are the reasons why they would get into disputes, I would just briefly mention about the sector itself. Real estate as a sector has been quite dynamic from independence, and any economy for that matter would be called developing or developed based on its infrastructure. And hence, real estate plays and always has played the most important aspect in a country's development. However, from the time of independence, this sector has remained almost unregulated. On the contrary, every other sector like telecom and related sectors have one regulatory authority to actually control them or even redress disputes. But this one sector never had such a benefit for both builders, who are called as promoters, and also with regard to other people, that is home buyers or people who would want to buy the property. So when this discussion with regard to why a law was required, the first point which was put up, or rather I would say the last agenda on the discussion table, as I'm quoting the present Vice President of India, as then he was the Housing and Development Minister, saying that a law is required for a robust development of real estate sector and at the same time promote welfare of home buyers who have multiple investments which is coming out of their hard-earned money. So the reason for this act to come into place also was that there was no standardization at any point of time. Like other industries where they had a minimum requirement threshold limit to meet, this particular sector did not have it. At the same time, not all, but few developers and builders lacked even professionalism. As a consequence, what used to happen is the end sufferer was the consumer or the home buyer or the buyer himself. The reason I'm trying to distinguish between a home buyer and buyer is extremely important here. At the time when this act was coming into place, or even they decided to go about with it, The biggest disadvantage they had was there was a severe backlash from the industry to say do not include commercial sector into this. However, finally, they included even commercial sectors and commercial buildings within the ambit of this particular act. So, in general, this particular act promoted three important things according to me. And I would call those three important things in three words called ACT. ACT. A for accountability, C for consumer protection, and T for transparency in every single dealing which is being conducted. Now, with this particular background, with regard to why this act, it's a diverse topic where we can just go into it, why this act was needed. Though it was introduced in the year 2008, it took 8 long years to be passed as a law and implemented in every single state. We can speak hours together on it, why this it took so much time for the industry to be regulated. But I want to cut short on that part so that I can concentrate on the main topic here, which is about the advantages which is conferred upon a home buyer. Now, every time we would want to go and buy a property, there was a time in Bangalore. I'm giving an example of Bangalore because I've been born and brought up and raised in Bangalore. There was a time in Bangalore where if you wanted to purchase a property, no questions asked, the property meant a piece of land, a site, or an agricultural property with definite dimensions, definite ownership. The only compliance was with regard to whether if you had obtained the katas, if you have paid the taxes on time. That was the only concern. But with the development of different sectors in Bangalore city, the need for housing kept on increasing. And now when we say we want to buy a property, the first thing we as an advocate, we ask our clients or intersay our own people is that do we, or rather, are you purchasing a flat? Are you purchasing a building? Or what is the property and area which you are purchasing? And this becomes important here. Prior to 2016, no guidelines with regard to how, what, and when are we going to have a definition with regard to say what is the carpet area, what is the extent of area which you are purchasing. And now as a home buyer, I have the benefit under the Act. So the larger benefits which are conferred upon a home buyer is that I as a home buyer, as of today, whenever I visit, I would definitely 99% it would usually be with regard to a flat being purchased. So when I'm going as a home buyer to a builder, what is that I should be knowing? And what is that law confers upon me? It might not be clear as a right of a home buyer, but it is clear as it is a duty of the builder. A right is a correspondence to a duty. So, as a home buyer, the minute you walk in, the first and foremost requirement you would be having is what is the project? What are the which flat or which property you would want to be purchasing? So the answer to that is the builder would be giving you a prospectus, a brochure. Now, the obligation upon the home buyer and the right of the obligation on a builder and a corresponding right of the home buyer starts from there. The first thing which as a home buyer we need to be checking, or I need to be checking, is that whether this particular project has been registered with the regulatory authority or not. And you may ask why Why is that needed? Many a times when you're going for due diligence for the properties, there are a list of documents which we as advocates ask for, such as whether do you have a sanction plan, whether do you have a license plan, any starting of the certificate, commencement certificate, and all these things. In a similar manner, the number which is being provided by the real estate regulatory authority would give you a prima facie idea with regard to whether or not this particular project has all these documents. And what are these documents? Depending on the home buyer, I would classify the home buyers into three parts. Type 1 home buyers are with regard to people who would want to purchase the property before the construction begins or starts. Type 2 purchasers are people who would want to purchase a flat in between the construction. And type 3 are people who would want to purchase a flat after the completion. That is after the superstructure has been put up. The advantage between all these different types of home buyers is that you would be conferred with the benefit of an economic benefit of saying you'll be saving about 10 to 20% of the money if you're buying before the construction starts, or after the construction starts, or after the construction is completed. So it is an economic benefit which the home buyer would be requiring or would be having benefited to. Now, when you go and seek for the prospectus, the first item you would want to see, or the first item you would want to see on the brochure, is the fact that whether it's been registered with the authority. And the minute it is registered with the authority, you have the option either to ask the builder to provide those documents, such as sanction plan, what is the time frame in which the building is ought to be completed, or the construction, the approvals from the local authority, the commencement certificate, which will be given only upon getting an approval from the other authorities, and what would be the cost of it. Now, once you ascertain these aspects from the builder, you would next go to get a documents with regard to it. If the builder is not providing you those documents, no harm. We are not blaming the builder here. But we would go to the next step whereby we can download these documents from the Real Estate Regulatory Authority's website, which is state specific. There's a clear website in the which has been launched by the state government of Karnataka, where all these documents are digitalized and uploaded. And you and me can, with a click of button, without paying any cost, can download these documents. You don't have to depend on the builder for these documents at all points of time. Now, the next question we will be looking at it is, which most of us have this, we would see huge banners which is being put up across Bangalore, across Karnataka, even across different states, is that what is the amount I'm required to pay the builder? And I'm being very clear on this, no amount exceeding 10% of the cost price of the apartment is ever being or should be paid to the builder. And that is conditional upon you signing the document. And that document which I'm referring to here is an agreement of sale. Why am I stressing on the word agreement of sale? Is because each of the builder have different kinds of agreements which are being made, drafted, documented, and vetted by we as an advocates who work for the builders on assignment, whereby the clauses are unilateral. I want to here give one of my personal experience. I have referred almost about good 1,000 documents so far, dealt with almost more than 1,000 home buyers. The home buyer, whenever he's signing the document, it is required for him, without any doubt, to look into the aspect as to what is he paying for, whether the carpet area is mentioned, what are the common areas, what are the benefits he's getting. Many a times, there are few builders who have now reduced themselves into insolvency, whereby they have targeted home buyers by convincing them that by entering into an MOU, that itself is an agreement of sale, by telling them one aspect that it is not the name, it is the form we are giving you. But a detailed scrutiny after the injury or the damage is happening has come out with one feature, that they have not given any sort of ownership over that particular parcel of property, that is the apartment, to the home buyer. So it is extremely important that you read the agreement of sale every point. And another aspect which has to be kept in mind, now you may ask how, you may ask yourself as to how do I get a performer or an agreement or a standardized agreement with regard to the property. Again, the act and the rules have its place, and all these which I'm talking is available on the internet on their website. Last month, Karnataka state government came up with a draft or a model sale agreements which has to be implemented. They've amended Rule 8 of the regulation, and they have implemented this particular document, and it has to be followed by every single home buyer and builder, as we call it them as promoters. Now, this act also has given a greater benefit for the home buyers to ascertain what is the concept of a carpet area, common area, and how to ascertain it. Before this act, it used to be complete discretion of the builder or the promoter who's trying to sell his property, which would lead, for the same size of an apartment, you would pay X amount in the same locality or in the next apartment or the next construction, you would pay Y amount. And this distinction is not only because of the cost price per square feet, but is also because of the benefits which they were trying to accrue. Now, with this advent of this particular act, it's quite clear that carpet area is defined, and every builder should and shall abide by that definition. And as I mentioned at the beginning, the type 1 home buyers who would want to invest in a property for a better future, it is important for them to observe and note if they have got a registration and if they've got a commencement certificate. A lot of times, due to oversight, I should say, without any intention, the regulatory authority approves certain plans, certain construction projects, and it might be purely out of oversight. And we have seen that that particular construction does not have a commencement certificate. Instead, we have seen when we downloaded the documents and when we inquire what is that particular folder which is we are not able to open, we have got a response from the builder by providing us with a legal opinion. It has happened. So it is extremely important that as a home buyer, we have to conduct our initial due diligence. And this due diligence, of course, is being conducted by the regulatory authority, and that is when you get your number or the authority and the right to start construction. But it is always better for a home buyer to log in, take some time out, and to ensure all these documents are taken in place and looked at if they fall into type 1 home buyers who want to invest prior to the construction. In the same way, it is not possible for us to look for the properties except if we are on that very job. And sometimes we are contacted through some people called real estate agents. Again, this sector was even now to a large part is not regulated. But if you want to work with a home buyer and if you want to work with a builder whose project is registered under the act, you as a real estate agent has to have to go ahead and get a registration for yourself, and you are also bound by disclosures, and you can be held liable for any wrongdoing or going with the builder, colluding with the builder and selling an apartment or trying to sell an apartment which does not match the specification. I shall come to the about what is the remedy which we have in the event we come across that situation. Now, I would get into the second part or the second type of the home buyer, which usually we all are, majority of them, is that the project is commenced, either one or two towers have been completed or is under construction, superstructure is being put up, and then you want to purchase the property. Nevertheless, it's an option which is bestowed upon each one of us as to how and when we have to be purchasing the property. And in the event you're purchasing the property in stage 2 or as a home buyer type 2, and again as a disclaimer, these classifications are not given under any act. It has been done by me when I'm with what we have seen with our clients and other people. It is necessary for you to ask the home buyer whether if he has got an escrow account. Again, now the concept and the meaning of escrow is quite known to everybody. But for the benefit of viewers and other people who don't know this concept of escrow, it is the duty under the law on side of the promoter, who's the builder, to deposit 70% of the entire amount which he has received in that particular account. Again, when you look at the history as to how they arrived at 70%, it's quite fascinating. When the discussion was being taking place, and in the year 2013-14, when a select committee was put up in the Rajya Sabha, it was a dissent opinion which suggested 70%, and the logic behind that is to ensure that one builder does not take the money which is invested by the home buyer to another project. It is similar to that of a term loan or a project loan which is given by the bank to any one of us. you have to use the money only for the purpose and the and benefit of the project which you have started, and no other way. Likewise, a builder once starts commencement of project A and collects the amount, he has no other choice but to use the money for the same project. And again, the rationale behind this particular rule or the law is that a lot of builders have tried to collect money from one project and take the money to another project or use it for another purpose altogether. In this way, we have seen hundreds of home buyers left optionless but to fight in the court of law against that particular builder. So this particular rule with regard to having a minimum percentage in the escrow is important. And it is, we don't have to ask the builder. Every time he's asking you to pay, the minute you see the account, it is usually in a bank, nationalized bank, and it is also named as X project escrow account. In fact, even the GST payment which we are paying for upon the project is also going into the escrow account. So we don't have to ask them, but by the act itself, we'll get to know. And again, this particular conduct has increased the transparency in which the real estate sector is actually going forward. In fact, I had the benefit in the morning to read an article which was published on 7th of July 2020, which said in a global ranking, that is Global Real Estate Transparency Index, India, thanks to the act, has gone up to 34th position. Of course, a long way to go to the first position, but we have come a long way from being backward in terms of transparency and accountability, and I would give the credit to the act. So in this way, it is required for the person who's going for the purchase of the property to look at if the escrow account is made. And the second thing, which as a home buyer, whether you fall under type 1 or type 2 customers, that is before starting of the project or after starting of the project, is that you have the right to ask to give them the plan as to payment. And that is usually called CLP. And that means construction linked payment. And what is the benefit which is accruing at this point of time? Construction is connected with the payment which is being disbursed, and majority of the home buyers go and get a loan, and usually that is connected with the with the builder, and that builder, if at all, is not able to show progress in that in the stage, that is putting up of slab 1, slab 2, slab 4 and n number of slabs, dispersal, if it's not connected to the development of the project, you're at a chance, you're at a stage of losing the money. And why would I say so? We have seen in one of the cases which we dealt with, the release of money was not connected with the construction. So anybody who have taken got into an agreement of sale in the year, say Jan 2020, would be paying, say, about 10,000 rupees, for example. And according to him, the next stage is only, according to him, if it is not given in writing, he would end up paying more money even if the next stage of construction is not completed. And we have seen this. And that is why it is an important aspect to ensure that your bank, if you're taking a loan, is informed not to disperse loan if the construction is not taking place. And again, one advice or suggestion which we have come across every time when we deal with such issues is that home buyers, once they take a loan and once the dispersal is starting or it started, they stop asking or visiting the premises. Of course, builders do say that only the bank authority is allowed and nobody else, but it's no written law. You can always ensure that you go visit the property, see if the construction is taking place at the right time and in the stage which has been promised to you. Again, if they're not doing so, I'll come to it later. So this is your right to ask for the stage-wise completion. And you also need to know, if you're a stage 2 customer or type 2 customer, how many number of flats has been sold, and you have the right to ask for it. In fact, it is a duty of the builder to update you as well as the authority in the name and the kind of number of flats which is being sold. And now coming to the last kind of or the type of purchasers whom I feel is extremely important and would also play a pivotal role in helping other people is at the stage after the construction and completion of the superstructure. It is necessary for each one of us to ask for something called completion certificate. As I said at the beginning, a person who's purchasing the property before construction, he needs to ask for commencement certificate. The same authority is now empowered to give a completion certificate. And what does this completion certificate mean for the home buyers? Completion certificate for the home buyers would mean the superstructure is completed as per the sanction plan. There's been no deviation, and and it is under process of taking other regulatory approvals. And that is where we come to the next point, which is important, is called occupancy certificate. Occupancy certificate, in simple words, means any certificate which would make your living, which would provide the entire premises in a habitable situation, such as providing you sanitation right, providing you gas links, providing NOC from fire department, pollution control board. This would allow you to ensure that you as a home buyer are safe and secure. And that is when possession certificate is given or occupancy certificate. More often what happens is the builders do not at any point of time get completion certificate but go on to give possession certificate on their letterhead. And I would want to be very clear here. At no point of time a possession certificate is valid if it's given on the builder's letterhead. It has to be given by the government authorities or a competent authority, and it has to be containing seal and signature of the competent authority mentioning the points which I have told. Only then the premises for you is habitable. If the builder does not allow you to go ahead with, or does not provide you with all these benefits upon completion, you are at a liberty to ask as a matter of right from the builder to provide all these benefits to you. In fact, one of the important thing which has to be noted after the completion is formation of a resident welfare association. You are conferred with that basic benefit of demanding it as a matter of right. If they don't give it, you can continue and go ahead with clearing those issues, and the builder ought to pay you as a compensation. And that is where I would move on to the next issue as to the structure in which the regulatory authority functions. The regulatory authority as a whole, as I mentioned before, is comprises of both judicial functions as well as administrative function. And I would now talk about the administrative function. The administrative function is something which would allow you to go ahead and get the documents from them. In many instances, when we are not able to ascertain documents, the authority has been kind enough by asking us to apply through Right to Information Act, and they have given us the information which we are looking for, which of course we have used it at the time when we have disputes with the builder. Likewise, this entire forum is both interactive and informative. And why would I say it interactive? There is a dedicated team which operates all the time during the working hours to ensure that you as a home buyer, if you have any query with regard to that particular project, is responded, and they ensure that you are given an answer. And how do you do it? Again, thanks to digital revolution, as I call it, that you just log into their website and seek for an information, and a ticket is raised in your name and a number is provided. And most often or not, they respond to you within 24 to 48 hours. It is their obligation upon them, which the law confers and as a right to you, to ask your questions about the project, and they have to close the entire issue within a stipulated time. And that would be anywhere between 24 to 48 hours. Now, now the question is, that is with regard to informative. That is with regard to, I stand corrected. That's with regard to interactive. And information, they act as an authority to collect information on your behalf. See, a lot of home buyers, as we recommend them to go and get their documentation checked with any counsel, any advocate, a lot of them avoid doing that for multiple reasons, reasons best known to them. They themselves can do due diligence of the basic properties by ensuring that they visit the website, download the documents, and if they're not able to understand, get to the next level, ask for clarification from the authority and the builder. And that's a second point of, that's a second due diligence of the property. And we still recommend at all points of time that, due diligence of the property, whether self or through a third party, should be done while purchasing the property or an apartment. And these documents, it's available on the internet, and you go ahead and you ensure that you download it and check for yourself. And that is why I call this particular authority as interactive. And now to the third leg, and just to continue from just as a last point, the law has given quite a diverse dispute resolution system. Not long driven, it is a short dispute resolution system whereby there's an authority called Real Estate Regulatory Authority dealing with certain aspects, such as if any of the obligations are not conferred or confirmed by the promoter, then you can move that particular authority, and from there it is an appellate tribunal which is also present in Bangalore, and from there you go to the High Court, and from there it is Supreme Court. And I can tell you with my experience, from the time the act has been enacted, they have been quite fast in resolving disputes. In fact, the act itself has provided or subdelegated an authority called adjudicating authority to deal with issues of compensation. Now, as I mentioned to you earlier, what if there's no sanction plan? What if the escrow account is not maintained? What if the completion certificate is not done? What if there's alteration with regard to this structure? You don't have to wait. You don't have to wait and fight a litigation in court as in other cases for compensation. An adjudicating authority, by paying a simple fee of 1,000 rupees, an online application can be made on their website highlighting the issue, and in the event you want any interim relief, interim compensation, and they're duty bound to dispose of the dispute or the issue within 60 days. And I can tell you with utmost certainty, the real estate, the adjudicating authority has in Karnataka, in Bangalore, has been by far the fastest and most quick in terms of resolving disputes. They have ensured that unless and until there's a grave disturbance, like for example, what happened with regard to the COVID-19, when there's disruption in the court work, 60 days is not compromised. Even at the time of issuance of notice, they make it very clear to the builder that you have to represent, and if you don't, we will go ahead and proceed with awarding compensation. And now again, a lot of people keep asking, or rather every person who looks at the authority would be thinking, what are the factors which should be governing the entire issue for compensation? I'll give you a simple example. One of my client, long time ago, after the enactment of this Real Estate Regulatory Authority Act, Regulation Development Act, had come to me with an issue saying that, sir, I live in South Bangalore, Bannerghatta. Now, I was sending my kid or my child to a school in South Bangalore. Now, I have decided to shift him to a school in North Bangalore, and for other beneficial things and to place of my work, I am also shifting and have purchased an apartment. Now, while he was doing so, while I was happy, the story was going good, the dispute which arose was the builder was not able to give the flat on time. So the question which came up to me is that, sir, how is that I can benefit? The builder, by the time we went about issuing notice and filing other issues, it definitely gave the delivery of possession. But the possession date was 1 year after the date committed. So for that 1 year, we ended up getting compensation before the adjudicating authority. And what are the factors we urged? One is the school van fee, which we had to be paying for the child. Second, the rental money which I was paying for my apartment while I was living in South Bangalore for that 1 year. And then the travel hours which got disrupted. And also, unfortunately, during this entire thing, my client also met with a small accident. And we were able to convince the authority that, it was only because of traveling from South Bangalore to North Bangalore that did my client get that particular injury. Adjudicating authority was convinced and it gave us the compensation. Again, this is one example. Even the law provides for certain criteria while giving compensation. And one of it being, what is the advantage, fair or unfair advantage accrued to which side of the party? And that is where I bring in the rental, which my client was not able to pay. At the same time, the interest which he was paying to the bank and the school van fee. And the loss which is being caused to him, the monetary loss. And how repetitive can be this particular default. So the builder which we were looking at had not done it for one, but for all. So the issue was quite repetitive in nature. Therefore, that is the way adjudicating authority performs, and that too within 2 months. And all your issues are sorted with regard to compensation. Now, the general dispute, the last leg of our discussion today, is with regard to how are we going to go about what are the common form of disputes which accrue between the builder and the home buyer. One of them is that false and misleading advertisements. For that, you can seek for compensation. The second one, if the construction is not happening as per the schedule, or if there's any alteration which is being caused without your permission. I want to tell the home buyers one more thing, is that once a particular plan has been submitted to the authority as well as home buyers, the builder cannot divert from there unless he has got a majority of the consent, or we call it as 2/3 of the consent. He cannot go about building an additional floor, or he cannot come up with an additional apartment or a balcony. And that requires your permission. And that, if is breached, can go to a situation where that can be demolished and you can get compensation. And this issue is not happening now, but it was the most common dispute between 2017, and few cases are still going before the authority, adjudicating authorities, delay in giving possession of the flat. At this point of time, there was a concept which was being circulated among the home buyers and builders starting from 2004 and 5. It's called, you have an agreement of sale, you have a construction agreement, and you have something called an exit agreement. Now, what was this exit agreement and what is the importance with regard to the dispute resolution I'm talking about now? It was one such marketing technique which was adopted by the builder to ensure and to assure that a particular flat has been sold. Once the flat is sold, if he is not able to complete the project within a stipulated time, or before 1 year the stipulated time, or 1 or 2 years or 1 or 2 months, he would assure you that he will buy back the entire property from you and give you an exit from the entire project. Now, I should tell you, this concept was a hit in the market. Top builders at that point of time followed this particular practice. And even home buyers got into it by hoping that in the event I don't want to purchase the flat after 3 years, or I don't want to live in that flat for 3 years, I can get an exit and walk out. And I will get back my money with something called as an opportunity cost. For an investment about for 7 lakhs, a simple economics, after 3 years or 2 years, you're getting back about 3 lakhs. It is definitely an economical, it's definitely beneficial for the home buyer. Like this, a lot of projects started being sold and money was being collected. And where this issue comes relevant for dispute resolution is that there was an inherent clause, one hidden clause in all these exit agreements, which has to be read if any home buyer comes across, is that the time at which he can offer himself for selling the flat. If the time is beyond, say for example, the project has to be completed in the year 2021. And if the exit agreement goes on to say that you have to offer your flat to sale to the builder in the month of June 2020, and that too before 15th of June, anything which is beyond 1 day, you would not be able to get the benefit of it. Now, a lot of home buyers who invested in the projects prior to 2016 had this confusion. However, the Act gave a simple solution for every single home buyer, and that is an inherent exit clause. And here I would want to make a mention of the section. It is called Section 18 of the Act. It gave the benefit to the home buyer to ask for compensation if at all he doesn't, if there's a delay in the project, and to continue, or if the delay is beyond the time promised, he had the option to come out of it and with complete refund. However, there's one proviso which needs to be mentioned here, one exception. If the particular project, the due date is not over and you want to come out of the project, there will be certain amount of deductions in your booking amount only, and not for any other amount, only in your booking amount. So assuming for a moment you have paid say 3 lakhs as a booking amount, and you have paid a loan of about 14 lakhs, and the project is due to complete in the year 2021, you are in a position to ensure that you take an exit by foregoing a small part of the booking amount and getting a refund from the builder in which is extremely important. So these are the different kind of disputes which have to be resolved within 2 months from the date of the first hearing. And why would I say that date of first hearing is because with the advent of this particular act, and because it's an online application, everybody started sending too many applications for the same project, for the same apartment. And because of which there was a delay. And now real estate regulatory authority has ramped up and there's been quicker redressal of the issue. And now when we once we get there, having said so many positive things, it is necessary for the home buyer also to understand. And another aspect which I forgot to mention about dispute resolution is that this act brought a clarity with regard to where you can go for resolutions of your dispute. Prior to this, people were approaching Consumer Protection Act, going to the state forums, state district forums, state commissions, national commission. Or people would approach civil court. And the only disadvantage in approaching a civil court is that you have to pay a hefty court fee. And sometimes if the authority was a government authority, like say for example, if it was an authority like a BDA or a BBMP, people would approach High Court. Now, with all these promoters, whether you are a government authority such as BDA, whether you are a housing cooperative society or an individual or a company registered under the Companies Act, any dispute with regard to the builder and the home buyer should be referred to the real estate regulatory authority. And civil courts and like courts have been barred from being approached. There's an exception to this. Since you are obtaining a service which is defined under section 21D subclause 2 of the Consumer Protection Act, read with section 21F and G, which include building services, you may approach the consumer court, but you can, once you approach the consumer court, you cannot approach at the same time the adjudicating authority. You're stopped from doing so. If you wish to do so, you have to withdraw the proceedings before the consumer authority and come before the adjudicating authority. And it is recommended to always do that, is for one simple reason. If the amount of compensation is beyond, say, 1 crore, as of now, 2019 Consumer Protection Act has not come into force, so we are still under the old act. You have to approach the national forum, which is in Delhi. The advantage of approaching the adjudicating authority is that there's no limit. You may claim for 10,000 rupees as damages, or even 1 crore as damages. So you are on a beneficial level if you present yourself before the adjudicating authority. And that too, now with COVID situation, they've been kind enough, like all other courts, they're offering us Skype hearings and other video conferencing. So at the comfort of your house, at the comfort of our offices, we can make our submissions, and that too within 2 months, issues are settled. It is extremely rare that the disputes get precipitated and becomes complicated. it is very uncommon. But there are few builders who are named in the website itself as defaulters, and it is unfortunate that their registration is still not being cancelled. Of course, on different grounds. Probably nobody has applied for it. Probably they're showing development of it. So with this aspect, I would want to conclude on the issue of dispute resolution. And the final aspect is, even if even if you are able to ensure that you get one issue sorted, one thing which we have observed with the real estate regulatory authority is that they have less powers to execute the order. And I would restrict my statement with only this particular statement, that they have less powers to execute the order, and therefore it is important for all the home buyers, whether you fall under the categories I've defined as category 1, 2 and 3, that is before, during or after, to do absolute due diligence of the property. And now it's easier than before. At the comfort of your house, you can look at the project, if it's submitted in the right manner, and then you can always ensure that you have the right flat for yourself, or the right apartment. So with this, I would conclude my talk on the Real Estate Regulation Development Act.
Thank you so much, Mr. Mahesh. It was a very informative session. You have tried to give us a 360-degree view on the particular aspect topic, in fact. Before we move on to the Q&A session, I think we already have 3 offline questions. I'll try to read it out for you. Can we go ahead with the questions, Mr. Mahesh?
Sure, please.
Yeah, Mr. Shivaraman Hariharan has a question. How many cases are filed in Bangalore after this RERA law is passed? How many in consumer favor? How many in builder favor? Might be a difficult task to give you exact statistics, but nevertheless, you can give a gist of it, or it will be very difficult for you to give the precise statistics.
Yes, that's why in the entire talk I mentioned, I use these 2 words. That is, the website is both interactive and informative. So if you just go to the website, and if you're looking at any particular project, if you type the project name, you'll get all the judgments which has been answered in favor and against. So, and if the number of cases which is being disposed of is directly proportional to the number of cases which is gone for execution. So I would say about 80% of the cases which I have seen are in favor of the consumer.
All right. Thank you. The next question is, Mr. Mahesh, do you really think that the intention of the legislature is fulfilled when it comes to stipulated time frame?
Well, can you hear me?
Yeah, I'm able to hear you.
Yes. So, interesting question with regard to the intention itself. The intention is quite clean and clear. And the fact that majority of them are approaching the Real Estate Regulatory Authority as of today itself is a clear indication that the stipulated time frame is being complied with, as against any other similar forums which is there. So I think yes, I really think the intention of the legislature is fulfilled.
All right, thank you. So now let's move on to the online questions here. Mr. Akash, request you to unmute all the viewers so you can put forth your questions online.
Yes, Mr. Ashok Kumar, I have one question, sir.
Yes, sir, please go ahead.
Sir, you have enlightened us on a very recent act and amendment. I am very grateful and thankful to you and also the association. My first is zero payment. Payment starts on possession. What is the effect of getting the compensation in case of breach of terms of construction? Mr. Manish, did you follow me?
No, can you be a bit more clear, because you
Yes,
said
yes.
0%.
I have come across builder publishing zero payment on booking.
Okay.
And payment starts on possession.
Okay.
And
So
what is the effect on the compensation if they commit a breach of contract?
okay. So interesting. There are three aspects to the entire issue. You have seen a prospectus or a brochure which go on to say that 0% upon booking. And that's absolutely right. That's as per law. You shall not pay any amount until the date you sign the agreement of sale. And that is what the builder is trying to approach and give you the benefit. And again, I would want to say the builders are not giving you extraordinary benefits by making a statement like this. They're just following the law. And in the event there is a breach of compliance with regard to construction agreement, we need to again see what is that breach which they're talking about, whether the alteration is not being done. So the compensation would be directly proportionate and equivalent to the actual loss. And by just saying breach of construction agreement would be too large for us to look into it.
Here, compensation does not arise because I have not paid any amount on a booking.
So it's not that way. Compensation does arise. It's not about an agreement is formed even for the future payments.
Right, right. One more question. The cooperative society enter into a members cooperation to build and construct. Will it come under the definition of a regulatory authority? Cooperative society consisting of members who intend to construct a flat. Will they come under the definition?
Yes, sir. They do, sir. They are called as promoters.
Yes, sir. Thank you very much.
You're welcome.
Yeah, before we move on with the online question, we have one offline question here by Ms. Kasturi Rajiva. The question is, in the event of termination, is compensation which can be claimed by the purchaser under section 18 is in addition to the penalty envisaged by RERA, which is SBI prime lending rate?
Yes. So in the event of termination, that itself would lead to compensate. Again, who's terminating it is a big question. But if the home buyer is terminating the contract, he cannot do it unilaterally, nor can the home buyer do it unilaterally, because it goes against the principles of contracts. And yes, the interest which is levied, the SBI interest, which is 8.75% plus 2%, which is contemplated under the Rule 6 of the regulation, and you're bound to get that. So any amount you're getting from as a compensation would be coupled with the interest which is at the lending rate, plus 2% always. SBI percentage plus 2%. So usually you would get about 10.75% on every compensation you are getting. And it's a general rule which is being followed. And it is not in derogation with the Interest Act also.
All right. Thank you so much.
Mr. Mahesh,
Can we
I have a question.
Yes, sir.
Mr. Mahesh, do you hear me?
Yes, sir.
Yes, sir.
I am Krishnamurthy.
Yes, sir.
I have a question.
Yes, sir.
See, if there is a delay in completion of the construction and delivery of the possession, I can
Yes,
file
sir.
a complaint for compensation before the adjudicating authority. That is one alternative available to me. again, I can also file a complaint before the RERA authority, which may end up in levying some penalty on the developer. So in what way does it help me if I file a complaint before the authority, which will result in payment of some penalty?
So if penalty itself is your sole concern, if penalty is only your sole concern, then going twice would not arise, or going twice would not serve anybody's benefit. But what you can be achieving is beyond penalty if you go before the regulatory authority to ensure that the builder completes his project.
Can I file a complaint before the adjudicating authority, and simultaneously can I file a complaint before the authority also?
So you
RERA
can
authority
file
also?
the complaint before adjudicating authority for sake of compensation
Yes.
for designated violations only. Designated violations, such as if there's an advertisement breach, if the possession, there's a delay in delivery of possession,
Yes.
or if the promoter fails to complete, or if he's unable to give it, or there's any violation in the superstructure. So that would entitle you to get compensation. So these are designated. There are other violations which would cause for penalty, which is somewhere between section 59 to almost section 69. Almost 10 sections cover that. So we might have to look into it in a much more detailed manner, probably to address your concerns, sir.
No, my point is there is a delay which is covered, and which entails me to file a complaint before the adjudicating officer seeking compensation. For the same type of delay, Act also provides, I think, that I can file a complaint before the RERA authority. Can I simultaneously choose to file both the complaints? That is my
No,
question.
sir, you can't. You can't if it's only for penalty. If it's only for penalty, you can't do that, sir.
Okay, okay. Thank you.
Yeah, yeah. Well,
Can we go ahead with the next question, please? Yes, sir. I think you have to unmute yourself.
Hello. Hello, sir. This is Mallikarjun.
Yes, Mr. Mallikarjun.
Yeah, good evening, sir. It is a very quite informative session, Mr. Mahesh. I would like to ask, apart from that buying homes, what would be the procedure in buying plots? Would it be the same procedure and followed by buying the plots, and whether it applicable to only Bangalore or to municipal areas also?
Welcome, sir. I was not able to hear Mallikarjun, sir. Can you repeat?
Mr. Mallikarjun, could you please repeat the question?
Sir, apart from that buying homes, would it be applicable to buying plots? The same procedure we have to follow, or the different procedures are there? Would it be applicable to even Bangalore or so to municipal areas also?
So any construction which is exceeding beyond 500 square meters and exceeding 8 floors would come under the
8 apartments.
8 apartments. I'm sorry, 8 apartments. It would this act would be applicable, sir. In fact, here I would want to say, at the time of discussion of this enactment, the builders were actually insisting upon making it 12 apartments and excluding commercial properties. But now it is applicable to everybody. In fact, Mallikarjun, sir, I should be clear. This act may not be applicable as to buying a single site, or it is not applicable to buy a single site. It is applicable only if it is 500 square meters or above and 8 flats or above. Okay. And yes, it is applicable to all municipal locations.
So what my clarification, what would I like that? Suppose the builder is developing a layout like that, 5 acres, 2 acres, 1 acre, like that in the municipal areas. They are not registered under the RERA. Still, they are required to register under RERA. And what about the preventive immunity for the purchases?
So, yeah, you may have to speak with me in person You can have my email ID so that you can refer and we can have a discussion about this.
Thank you, sir. Thank you.
Yeah, Mr.
And
Mahesh.
at the end of the session, we will try to share the email ID of Mr. Mahesh Chowdhary. So you may, in detail, put forth your query through your mail, right? And we'll have the next question, please.
Vikram, I am Rangarajan here.
Yes, sir. Please go ahead.
Good evening, Mr. Mahesh.
So, namaste, sir.
Namaste. Now, I have 3 questions, which are, according to me, gray areas in the Act. Question number 1. There are various quasi-judicial authorities under the RERA Act, be it authority, adjudicating authority, advisory council, even the tribunal. I find from the rules and the Act that only government servants would be appointed to these bodies. Is it not desirable that there must be some legal mind also in these bodies so that justice delivery system will not suffer? Number 2, the authorities under the Act must be designated as civil courts for purposes of execution, and an order passed by an authority should be deemed to be a decree so that the home buyer or anyone who goes before the authority would not suffer. That is question number 1. What are your kind views?
Thank you, sir. These are questions which bother all of us when we are practicing in these sector. In fact, the first question which you asked for came under detailed consideration before the Bombay High Court, saying, should you not have a judicial member? So the answer was an affirmative. They said, yes, you should have an authority constituting a judicial member. In fact, I would just want to draw up small parallels recently which happened in state of Karnataka also. There's an authority called KERC, which deals with electricity aspects of tariff matters, not business to consumer matters. It's B2B. So there the same issue had come up and the Supreme Court held categorically that yes, they need to be a judicial member on the board. So to that aspect, sir, I would say it is not gray in terms of both our views, but it may be gray only in terms of execution. And so the second question you mentioning was, yes, we strongly believe that it should be a decree. Even if the civil court, even if the adjudicating authority is not designated as a civil court, it should be conferred upon the executing powers, which is given under Order 21 of CPC.
CPC, correct.
It should be given, mandatory, it should be given, and it should also be termed as a decree because it will help us, if not here.
Like in Arbitration Act, an award is deemed to be a decree under the Arbitration Act.
Absolutely, sir. Absolutely. I go to the knowledge.
I have, sorry.
So I was just trying to tell you that, yes, there is a, as I said, it is not a gray area for you and me because we are firm about the decision taken, but it's only about the implementation and convincing probably the implementation. So yes, sir.
My next question is something like this. See, in any real estate transaction, particularly the construction of multi-dwelling residential apartments, majority of the cases, there will be 3 parties. One, a landlord who has offered his land for development. Then the promoter who develops. Then ultimately there are home buyers, etc., etc. Now, the Act does not separately define the landlord. It only encompasses within itself. The definition of the promoter includes the developer and the landowner also. Would it not be more clarificatory? Because suppose as a landowner, I am also aggrieved because of delay in delivery, diversion of funds, poor quality, lack of infrastructure, I will be one promoter filing a case against another promoter. What are your views?
I think it's again all three interesting questions. So the point which I feel is that we need to understand the scheme of the act, you know, and who's it being targeted to. If you look at the last speech which was given just before this bill was sent to the president for his assent, as I told at the beginning, the present Vice President of India, as then he was the Housing and Development Minister, Venkaiah Naidu sir, he made a very categorical point with regard to one, yes, development of the sector, but it is more important to have an act to save the interest of the home buyers. So far as the law intention is concerned, the objects are concerned, and the reasoning is concerned, and the end target has always been home buyers. And the issue which you're trying to say between one promoter pitching against another promoter,
Exactly.
that sir is not answered here for that reason. Because
Possibly
they
we
come
may
as
have to
one
go to
unit.
civil court.
So it again, as I don't want to transgress on that, but yes, I mean, the unit which is being referred to is promoter and allottee. These are the only two. The dichotomy is only between these two people,
Correct.
and it's not
The,
beyond that.
correct. The landowner is not in the picture.
Yes, so we need to look at the intention, because in that way, if you look at it, a lot of laws can be more clarifactory in nature than being, in actual, the way you said, why didn't they get civil court powers? In fact, we also are trying to figure out and trying to convince the courts that yes, it should have civil court powers. It's easier, but they have a different argument. But yes, let's keep that aside. So I think I've answered your question, sir.
Yeah, Mr. Mahesh. Yeah,
Sir.
this is Harish here.
Yes, sir.
Can you hear me?
Yes, sir.
Yeah.
Tell me.
Sorry, section 11, subclause 4E. Okay, speaks of formation of an association. Okay, it talks about formation of an association to be facilitated by the builder. Okay,
Yes.
And there is also a clause which says within 3 months from the date of booking of the apartment, association should be formed. In the mere booking stage, why will the builder want to facilitate a formation of an association? And where will there cannot be any 2/3 members already occupying the apartments also.
So you need to read that in tandem with the previous sections also. The subclause.
Even then, but it says very clearly 3 months from the date of the 2/3 people booking the apartment. It doesn't say occupying. See, you can't even give delivery of possession without OC. This is a major conflicting area in the Act. The other one is, you see, 11(4)(f), which says transfer of, you have to convey the title of the apartment, okay, along with undivided share, and then common areas to be conveyed to the association. See, it is conveyance of common areas to the association. Assume tomorrow you convey, show me any builder in Bangalore. I have been in this line and for a couple of decades. Show me any builder in Bangalore who is after RERA has been able to convey the common area to the association. If conveyed, tomorrow if the building collapses, then what happens to the common area undivided share component? According to the Act, if you interpret, the undivided share itself should be conveyed to the association. You see section 18 also. See, please read section 17 also. Transfer of title. There also it says the same thing. That the common areas to be conveyed to the association. That's how it says. And apart from that, you can also see that association formation is now being done under the Apartment Ownership Act. Everybody does DOD under the Apartment Ownership Act. Nobody does DOD under RERA. Where is the provision for DOD under RERA? Okay. If you see section 92, repeal provision of this Act. in this repeal provision of this act, it says Maharashtra Apartment Ownership Act is repealed. All other state government, state apartment acts have never been repealed. Once RERA has been brought into the, I think, in Apartment Ownership Act, Sale and Promotion of Apartment and Ownership Act, all these acts should have been repealed. This conflicting people today also, as on date, I know a lot of builders where DOD is done and under the Apartment Ownership Act. Either they do it in Form B or Form D, but never under the RERA, there is no provision for DOD at all. Formation of association to be facilitated. So builder will only make a platform for you to do. That can happen only after 2/3 members are already occupying. If you have a booking, you are neither by booking, you are neither an allotee nor a consumer. You are just an applicant. And you mentioned about this 0% booking, somebody was talking. See, booking advance, you can only take 10%. After plan sanction is done, only you can market. Till then, you can't market. So you can't even receive booking also before the plan sanction is done. Okay. And the remaining, whatever you want to take over and above 10%, you can only do with an execution of an agreement, not otherwise. So see, this DOD issue is a gray area. Lot of apartment complexes, they have not been able to form association because builder says, I don't do DOD, you do it. Because the Apartment Ownership Act says submit the apartment to the provisions of the act. So apartment owner has to submit. Builder will say, I am not the apartment owner, so I will not submit. But where the builder is himself the landowner, my suggestion to several of my clients has been, before you sell the first apartment, do the DOD yourself, so there won't be any conflict by any apartment owners tomorrow morning and after they come into picture. See, this is a gray area. I can name apartment complexes where there is a big tug of war, two apartment associations being formed for different blocks inside the same compound. And some of them are being litigated before the civil court even today.
Right.
Absolutely. So we are reaching the fag end of this session. It's almost 7:27. So that's the end of Q&A session. Do you have anything to share, Mr. Mahesh, on the last? In fact, I forgot the member's name. In fact, he has given us some input for all of us to think about it. So, do you want to share any view from your side?
See, I've been a firm believer of any act. You know, when we started, when I first heard about this act called VAT, Value Added Tax, in the year 2005. By the time the act was amended, changed, and everything, now immediately there's a new act called GST. So I think you need to law matures through a process of interactive thinking, like what the previous gentleman did ask. And I think yes, it is a cause of concern especially in two areas which he pointed out. And I was just thinking when Mr. Harish was actually asking, instead of this being a discussion and then a Q&A, it could have been a Q&A and then a discussion, because we could have covered it in much faster manner. So that's it. That's my view on it. But yes, I will definitely get back to Harish sir at some point with the answer.
Sure. As promised, can you please share your email ID with our learned members in case they have any queries? Let them feel free to contact you through email, because we are running short of time. I know Mr. Gupta sir also has a question, but apparently, sir, I'm so sorry, we are running short of time. So my apologies for that. So could you please share your email ID?
Sir, it's a bit tongue twister. So what I do is I'll just share the screen if it's possible, so that everybody can see.
That could be a difficult task at this point of time, because the technology here is we will have to make you as a host. So that would take some time.
They can contact me by just adding a to my name as what is being shown on the screen, and then adding it amaheshchowdhary@gmail.com.
I repeat, I'll just try to spell it AMAHESHCHWDHARY at
Yes.
gmail.com. All right.
Yes.
amaheshchowdhury@gmail.com.
The other email ID they could get in touch with me is amc@precinctlegal.com.
The first one would be a better one, so it would be easy for
Correct.
them to share their, use that particular email ID. All right, my many thanks to you, Mr. Mahesh, for a wonderful session, and you have educated us, and in fact, it was a very good presentation. All right, thank you so much.
Yeah, thank you for the association to have me on the panel with so many people watching it and having a benefit of even talking and understanding their perspective. Thank the association, and on behalf of association, I would want to also who's representing here, Gangadhar sir. Thank you so much for being throughout and watching the entire presentation, and everybody who's on the screen. Thank you.
Thank you so much. So can we log off this session now?
Sure, sir.
Thank you.